Hello, everyone, and welcome back. Before we continue on, I will remind you once again that I am not a lawyer of any kind and I am not certified to practice law in Vietnam. I'm just simply some foreigner from the United States who knows about the labor code. Now, today we're going to go ahead and talk about what happens when you have to go ahead and confront your English center or your employer. So, here's the situation. Say, for instance, something happens. Either, you know, they're trying to fire you and you don't agree with it, or you want to go ahead and get them in trouble because they've been breaking the law. So, how do you go about doing that? Well, here's the thing. The very first thing you have to think of is gather evidence. You cannot prosecute a case without evidence. And this evidence can be anything. It can be audio recordings, may or may not be illegal, so be careful if you do that, all right? I am not a lawyer. I'm just telling you that if you record, do so at your own risk. Now, those audio recordings may actually help you, though, so it depends. Anyways, moving on. So, besides audio recordings, you can also have things like emails, conversations, stuff like that, stuff like that. Normally, most evidence is gathered through text messages and chat apps like Zalo and things like that of employer misconduct. Now, other aspects of employer misconduct can go ahead and include things like, not punishing you properly because, they decided to dismiss you when all it really warranted was just a warning, stuff like that. Also, if your employer discriminated against you because, say, for instance, I don't know, say there's a promotion in your company, all right, and your employer has two people, you and another person. Now, both of you have the exact same qualifications, exact same everything, right? But for some reason, your employer chose the other person over you. Now, the thing is the fact that one would argue, well, if both people are exactly the same, how can you choose? Well, that's simple. If you have qualifications, experience, everything like that, the only thing you can really go on is merit. But also, if the person that wasn't chosen had higher merit, it's also because of the fact that the person that was chosen had a relationship of some kind with the employer. That's the reason why the other person got promoted. Now, we're going to go ahead and get started. Here we go. All right, so here we go. Chapter 14, Settlement of Labor Disputes. Now, remember what I said before in one of the previous videos, that when you gather all your evidence and you want to go ahead and really go ahead and make your English center or your employer understand you that they've been messing up and they need to answer before the law, what you do is simple. Like I said earlier, you simply go to the People's Committee of the district in which the English center or employer resides. Not you, them. And not their personal address, the business address. Wherever the business is, that's the district you have to go to, the People's Committee. Now, inside the People's Committee, there's a special area called, the labor area for, labor law violations and stuff like that. Well, you go ahead and talk to some labor counselors, and they can go ahead and help you get set up. Now, normally, cases can be handled, as far as I remember, back about like 7 days. And after that, they summon counsel, and after that, they have a discussion. Now, if the employer agrees to abide by the decision, that's one thing. If the employer refuses and wishes to take it to court, well, then you're going to have a battle, because a labor lawyer costs about $50 million and it takes about 4 to 6 months to complete your case. So we're going to move on. I'm going to go ahead and read this, and hopefully we'll have enough time. If not, I'm going to have to make a part B. So moving on. Section 1, General Provisions for Settlement of Labor Disputes. Article 179, Labor Disputes. Again, here's the English portion and Vietnamese portion. For those of you out there who can understand both, you will see that what I am saying is true, even though my comment is only in English. So let's move on. A labor dispute means a dispute over rights, obligations, and interests among the parties during the establishment, execution, or termination of a labor relation, a dispute between the representative organization of employees, a dispute over a relationship that is directly relevant to the labor relation. Types of labor disputes. Now, right here is the definition of what a labor dispute is. Pay attention. A dispute over rights. Right there. A dispute over rights. Obligations and interests among the parties during the establishment, execution, or termination of a labor relation. What this means is that a labor dispute is a dispute over all this. So, yeah, a lot of English teachers out there can sympathize that they've not been treated right, the obligations were never met, interests were never met during the establishment, before, during, or after the contract was terminated. Now, subclause A, let's keep it moving right there. Labor disputes between the employee and the employer, between the employee and the organization that sends the employee to work overseas under a contract, between the dispatched employee and the client enterprise. So, right there, disputes between the employee and the employer. That's a type of labor dispute. Moving on, letter B. Rights-based or interest-based collective labor disputes between one or several representative organizations of employees and the employer, or one or several representative organizations of employees. Clause 2. A right-based collective labor dispute of rights means a dispute between one or several representative organizations of employees and the employer, or one or several representative organizations of employees in case of discrepancies in interpretation and implementation of the collective bargaining agreement, internal labor regulations, and other lawful agreements. Discrepancies in interpretation and implementation of labor laws, the employer's discrimination against the employees or members of the management board of the representative organization of employees for reasons of establishment, operation, or participation in the organization, the employer's interference or influencing the representative organization of employees, the employer's violation against amicable negotiation. So that is literally what it said right there, A, B, and C, but that's all in English right there. So yeah. Now, this does not apply to English teachers. I'm just reading it anyways because why not? All right, now, here we go. The one part here, all this collective stuff means basically labor unions and stuff like that. Does not mean this is not for English teachers because that's like for unions and stuff. Now, moving on. Clause 3. Interest-based collective labor disputes include labor disputes that arise during the process of collective bargaining, union stuff. A party refuses to participate in the collective bargaining, or the collective bargaining is not held within the time limit prescribed by law. Again, that's stuff that does not apply to English teachers. Article 180, right here. 180, labor dispute settlement principles. Please pay attention to this. And for all of you evil English centers out there that are currently watching this, and I'm pretty sure there are some that are watching this now, I want you to remember this. Your greed has pushed people to lows that they did not think possible. Because of that, people like me are starting to stand up and say we're not going to take it anymore. That's the reason why people like me are starting to wake up and are starting to want to know our rights, starting to want to know how to protect ourselves. When you find yourself with a full classroom of students and no teachers because you don't know how to treat them properly, maybe you'll think back on the fact that if you had treated your teachers properly, you would have had a lot of staff. Anyways, we'll move on. Article 180, Labor Dispute Settlement Principles. Clause 1. Respect the parties' autonomy through negotiation throughout the process of the labor dispute settlement. Means don't mess with them. Clause 2. Prioritize labor dispute settlement through mediation and arbitration on the basis of respect for the rights and interests of the two disputing parties and respect for the public interest of the society in conformity with the law. So essentially it just means the same thing, just try to go ahead and keep it out of the court as much as possible, because if it can be settled peacefully, then it should be settled peacefully. You should only take it to court if the labor process is not the labor mediation process is not successful. Moving on. The labor dispute clause 3 shall be settled publicly, transparently, objectively, promptly, and lawfully. Pay attention to that first part. Publicly. Now, the thing is, though, is the fact that, in my opinion, it should be done that way. And evil English centers, they should be held accountable on the news, in fact, if necessary, to go ahead and basically name and shame any evil English center that doesn't treat their English teachers right. They need to be named and shamed for everybody to know. Everybody knows about APACs, and everybody knows about the clones of APACs, but they don't know about all these little mom and pop type English centers out here that really don't know anything about how to treat their employees properly. Oh yeah, there's several. And I bet you not all of them have a license. If only there was an oversight committee that could go ahead and actually go through every single English center here in Vietnam to check all the paperwork to make sure that all the teachers have all the paperwork in accordance with the law. And if there's any mistakes, their center gets shut down. Because I bet you that a lot of the English centers would, because I bet you their paperwork ain't right. All right, so moving on. Now we're moving on. Clause 4, right over here. All right. Ensure the participation of the representatives of each party in the labor dispute settlement process. Now, if you hire a lawyer, representative of each party. Now, normally your English center is more than likely going to have a lawyer on their team already, unless they're a mom and pop shop. If that's the case, then they may go ahead and hire a lawyer, but it may not be easy for them. Moving on. Clause 5. Labor dispute settlement shall be initiated by a competent authority or person after it is requested by a disputing party or by another competent authority or person and is agreed by the disputing parties. Now, essentially, labor dispute settlement shall be initiated by a competent authority. Now, one of the competent authorities is the Ministry of Labor. Now, they operate, like I said, an office inside of the People's Committee of the district in which the English center or employer is located at. So, yeah. All right, moving on. Article 181, responsibilities of organizations and individuals during labor dispute settlement. Right there. Clause 1. The labor authority shall cooperate with the representative organization of employees and representative organization of employees in giving instructions and assisting the parties during the labor process of labor dispute settlement. Yeah. I'm just going to go ahead and read some of this stuff out. If I can't think of an explanation, I'm just going to keep going because, yeah. So, just moving on. Clause 2. The Ministry of Labor, Invalids, and Social Affairs shall organize training to improve the professional capacity of labor mediators and arbitrators for labor dispute settlement. Self-explanatory. Clause 3. Right over here. The Provincial Labor Authority, when requested, shall receive and classify the requests for labor dispute settlement, provide instructions, and assist the parties during the process of labor dispute settlement. Within 5 working days, the receiving authority shall transfer the request to the labor mediators if mediation is mandatory, to the arbitral tribunal if the dispute has to be settled by arbitration, or instruct the parties to file the petition to the court. Moving on. The rights and obligations of the two parties in labor dispute settlement. Clause 1. During the labor dispute settlement process, the two disputing parties have the rights to participate directly or through a representative in the labor dispute settlement process, withdraw or change the contents of the request, request for a change of the person in charge of labor dispute settlement where there are reasonable grounds for believing that the person may not be impartial or objective. Clause 2. During the labor dispute settlement process, the two parties have the responsibility to, right over here, promptly and adequately provide documents and evidence to support his or her request. Abide by the agreement reached, decision of the arbitral tribunal, court judgment, or decision when it comes to an effect. Now, I'm going to go ahead and check my thing because, once again, I forgot to go ahead and set my timer. All right, let's see what we got here. We got this, and we got about 14 minutes. We're about halfway through. Sweet. All right, cool. So we can go ahead and continue on. All right, so we got definitely a few minutes left. We're going to go ahead and continue on. So, Article 183, rights of competent labor dispute settlement authorities and persons. Competent labor dispute settlement authorities and persons shall, within their mandates, have the rights to request the disputing parties, relevant organizations, and individuals to provide documents and evidence, request verification, and invite witnesses and other relevant persons. So essentially, the people that are in charge of the labor dispute settlements can summon people to, like, they can go ahead. Okay, let me go ahead and think of it like this. All right, so to provide documents, have the rights to request disputing parties to provide documents and evidence. So disputing parties, relevant organizations, to provide documents and evidence. So you have to provide documents and evidence to support your case. If you don't, you can't just go in and say he did this and then that's it. Request verification. So if you dispute something, you can request verification of whatever the other person has and invite witnesses and other relevant persons that will help support your case. So that's what that means. So you are allowed to invite people, witnesses, and stuff like that. Labor mediators, Article 184. English, Vietnamese. Labor mediators, Clause 1, shall be assigned by the Provincial Labor Authority to mediate labor disputes and disputes over vocational training contracts, assist in development of labor relations. Clause 2. The government shall provide for the standards, procedures for assignments, benefits, working conditions, and management of labor mediators, power, and procedures for dispatching labor mediators. Article 185, Labor Arbitration Council. Now, this is a lot of stuff that I know is very boring and dry, but at the same time, this is something you really, really, really need to know if you're going to go ahead and take your English center through the ringer, so to speak. Because the very first step, you can just simply take them to court if you really want to. But the very first step, in my opinion, the proper way, you have to go ahead and get them through the labor mediation process. Because if it's either labor mediation, labor arbitration, whatever happens, the fact that you've taken that first legal step. And then if something happens and it's not agreed upon, whatever else, then you take it to court. Then you have evidence of, hey, we did this first, this didn't work. That actually helps the court later on. So that's the reason why you should go through mediation first instead of taking it straight to court, because then if things don't go your way, you can go ahead and have evidence to say, hey, we got evidence. Water break, one moment. All right, I am feeling much better, and I may do actually another video. I don't know, it depends on how I feel. I'm trying to do at least one video a day. I know I was pumping out about 5 earlier, but I'm trying to do at least one video a day. I might be doing a bunch more short videos later on just talking about stuff, but I am feeling a lot better. It's just there's still a little bit of sickness going around my house. Anyways, moving on. We got about maybe, I think, 10 minutes left before I have to go ahead and cut this short. Let's see. Yeah, we got about 12 minutes left, so we really got to start wrapping this up. Okay. So, Article 185, Labor Arbitration Council. Clause 1. The President of the People's Committee of the province shall issue the decision to establish the Labor Arbitration Council, designated chairperson, secretary, and labor arbitrators. The tenure of a Labor Arbitration Council is 5 years. Clause 2, down here. The president of the People's Committee of the province shall decide the number of labor arbiters or arbitrators, which is at least 15. The number of labor arbitrators nominated by each party shall be specific. Shall be equal. Nominated by each party shall be equal. To be specific. Roll it up. All right. To be specific. At least 5 labor arbitrators shall be nominated by the Provincial Labor Authority. The chairperson and secretary shall be officials of the Provincial Labor Authority. At least 5 labor arbitrators shall be nominated by the Provincial Trade Union. At least 5 arbitrators shall be nominated by the representative organizations of employees in the province. Yeah, it's that serious. That's the reason why you need to know all this stuff. All right? This is why, right here, you need to know all this stuff. All right? So again, clause 2, right there. This is some serious stuff here. All right? Let's move on. Let's see what else we can do. I know we don't got that much time left. Standards of working conditions of labor arbitrators. A labor arbitrator shall conversant with law, experienced in labor relations, reputable, and objective. When nominating labor arbitrators as prescribed in Clause 2 of this article, the Provincial Labor Authority, Provincial Trade Union, and representative organizations of employees may nominate their people or other people that fully satisfy the standards for labor arbitrators. The Secretary of the Labor Arbitration Council shall perform its regular duties. Labor arbitrators may work on a full-time or part-time basis. Excuse me. Let's move on. Article 4. I know I'm reading a little fast, but I know we don't have that much time left, and there's really not much I can explain right now, so that's why I'm trying to go through it. All right, now, we got about, I don't know, maybe 5 minutes left. Let's see. I know I shouldn't be clicking back and forth all the time. This is why I need to go ahead and set my alarm, and I forgot to do it again. All right, so Clause 4. Whenever a request for labor dispute settlement is received as prescribed in Article 189, 193, 197 of this Labor Code, Labor Arbitration Council shall establish an arbitral tribunal as follows: 189, 193, and 197. The representative of each disputing party shall choose one labor arbiter from the list of labor arbiters. The labor arbitrators, I don't know why I keep saying arbiters. The labor arbitrators, move it on up, right here. All right, so the labor arbitrators chosen by the parties as prescribed in point A of this clause shall choose one other labor arbitrator as a chief of the arbitral tribunal. In case a labor arbitrator is selected by more than one disputing party, the arbitral tribunal shall appoint one of the chosen arbitrators. Clause 5. The arbitral tribunal shall work on the principle of collectives and make decisions under the majority rule, except for the cases specified in point C, Clause 4 of this article. Clause 6. The government shall provide for the procedures, requirements, procedures for designation, dismissal, benefits, and working conditions of labor arbitrators and labor arbitration councils, organization and operation of labor arbitration councils, establishment and operation of the arbitral tribunals mentioned in this article. And moving on up, Article 186. Prohibition of unilateral actions during the process of labor dispute settlement. None of the disputing parties shall take unilateral actions against the other party while the labor dispute is being settled by a competent authority or person within the time limit specified in this labor code. Now, unilateral actions, I think what this means is like a lawsuit. If you try to start a lawsuit at the same time you're taking this person through the labor dispute settlement process, it's going to be worse for you. So, yeah. All right, so competence and procedures for settlement of individual labor disputes. I know this is really, really long. Trust me. We may actually make a part B. Competence and procedures for settlement of individual labor disputes. Competence to settle individual labor disputes. The following agencies, organizations, and individuals have the competence to settle individual labor disputes: labor mediators, labor arbitration councils, and the People's Court. People's Court, right there. See, look. Da-dum, 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 da-dum. Right there. All right, now, moving on. All right. Article 188, Procedures for the Settlement of Individual Labor Disputes by Labor Mediators. Clause 1. Individual labor disputes shall be settled through mediation by labor mediators before being brought to the Labor Arbitration Council or the court, except for the following labor disputes for which mediation is not mandatory. Shall be individual labor disputes. I hope you paid attention to that. Disputes over dismissal for disciplinary reasons, unilateral termination of employment contracts. That right there. Right there. Except for the following labor disputes for which mediation is not mandatory. It's not mandatory. So if you wanted to take it directly to court, you can. So some cases require mediation. Other cases require that you go directly to court. But remember, if you take it through mediation first and it's not successful, at least you have that extra documentation to help you out. So it's up to you. You can take it directly to court if it's disputes over dismissal for disciplinary reasons, unilateral termination of employment contracts, disputes over damages and allowances upon termination of employment contracts, disputes between a domestic worker and his or her employer. The list just keeps getting better and better. Disputes over social insurance in accordance with social insurance laws. Disputes over health insurance in accordance with health insurance laws. Disputes over unemployment insurance in accordance with employment laws. Disputes over insurance for occupational accidents and occupational disease in accordance with occupational safety and health laws. Double D. Yeah, this is getting really interesting, isn't it? Okay, let's go ahead and check and see how much time I got left. I have 5 minutes left. Okay, cool. I should be able to get this done then. All right, cool. Let's see. So double D with the slash through it. Disputes over damages between an employee and an organization that dispatches the employee to work overseas under a contract. Disputes between the dispatched employee and the client enterprise. Clause 2. The Labor Arbitration Council shall complete the mediation process within 5 working days from the receipt of the request from the disputing parties or the authority mentioned in Clause 3, Article 181 of this Labor Code. Both disputing parties must be present at the mediation meeting. The disputing parties may authorize another person to attend the mediation meeting. So the disputing party may authorize another person to attend the meeting in their place. The labor mediator shall instruct and assist the parties to negotiate with each other. In case two parties reach an agreement, the labor mediator shall prepare a written record of successful mediation, which bears the signatures of the disputing parties and the labor mediator. And right there, clause 4, right there. Boom. And let's see. In case two parties do not reach an agreement, the labor mediator shall recommend a mediation option for the disputing parties to consider. In case the parties agree with the recommended mediation option, the labor mediator shall prepare a written record of successful mediation, which bears the signatures of the disputing parties and the labor mediator. And I am keeping on going with this. Now, when the two parties do not agree with the recommended mediation option, or whereas one of the disputing parties is absent for the second time without a valid reason after having been legitimately summoned, the labor mediator shall prepare a written record of unsuccessful mediation, which bears the signatures of the present disputing parties and the labor mediator. Excuse me. Clause 5. Copies of the record of successful mediation or unsuccessful mediation shall be sent to the disputing parties within 1 working day from the date on which it is prepared. In case a disputing party fails to adhere to the agreement specified in the records of successful mediation, the other party may request the Labor Arbitration Council or the court to settle the case. That's number 6. Number 7. Okay, I'm going to have to wrap it up after this one. In case mediation is not mandatory as prescribed in Clause 1 of this article, the labor mediator fails to initiate the mediation by the deadline specified in Clause 2 of this article, or the mediation is unsuccessful as prescribed in Clause 4 of this article, the disputing parties may request the Labor Arbitration Council settle the dispute in accordance with Article 189 of this Labor Code, or request the court to settle the dispute. All right, now, I have to stop it here because my video is almost out of time. So there will be a part B because it's not quite done yet. I will go ahead and say that I went and checked. I have 39 total subscribers, 14 that are visible, 3 that actually want to show their profiles to other people on my page. So that's awesome. 39 subscribers. That's awesome. But the Hordes of Han need your donations to keep going, you know. The hordes of Han are growing strong, but like I said, I need your donations to keep this channel growing. Because of the fact that, I have no cash. My wallet's completely bone dry. I have nothing. My bank account's empty, my wallet's empty, everything's empty. And I need cash, I need, money orders, I need goods and services, I need all kinds of stuff. Send me an email to tuxedoshadow@gmail.com or send me a chat request through Google Chat, tuxedoshadow@gmail.com. Or go ahead and join the Zalo chat group if you are in Vietnam. And as always, have a good day, stay safe, make sure to tell all your friends. I want everyone to know what I know. Be safe.